Okay, everybody, welcome back to What's the Obsession True Crime. So tonight we are going to be talking about the Karen Reed case, and if this case and this trial can't get any crazier. We all know that the first Karen Reed trial happened where she was brought up on charges of manslaughter in the death of her boyfriend, Boston Officer John O'Keefe, and that jury hung. And we're going to hear from one of the jurors during this live stream today about one specific point of contention that has come up recently in the second trial's pretrial proceedings. Because guess what? Because the jury was hung, Karen Reed is eligible to be retried, and that case thus far is slated to begin on April 1st, April Fool's Day, 2025. And, like just over a month at this point. And oh my God, can't wait for this next trial. This first trial and everything around this case has been filled with insane controversy and drama. And what is going to happen next is anybody's guess. But the most important thing here is that we find complete justice for everybody involved, especially for victim Officer John O'Keefe, and of course for Karen Reed, because if she did nothing wrong, then she should not be convicted of this horrible crime. She's been working very hard to not be convicted of this horrible crime. She spent her life savings. She's a very successful woman who worked in finance, who was a professor, and her legal bills with her excellent legal counsel have just racked up into I don't even know how much it is at this point. I lost track at some point, but it's a whole lot. So let's just talk about what happened just this past week and the second trial's pre-trial proceedings. We're going to kind of work backwards, but bear with me. I was trying to figure out the best way to present the information to you guys. And welcome to those of you who are here. Please hit like and share if you can. Whoops. How do I get back to, there we go. And let's see, welcome Jamie, Sherry, Tony, Sub Rosa, all my friends. Hey, Justice Jane, how are you doing? Thank you, Justice Jane. Edward, how are you doing, my friend? It's great to see you. Hi, Jody. And if McJ is here, hello, McJ. How's it going? Nice to see you. I know that you were waiting for this one. I just texted her to let her know that this was going on. So I know that this document isn't very big right here. Let me see if I can maximize it, but I'm going to read it to you, so it's no big deal. Oh, wait, I can. Here. Woo! Not that much. Sorry, I just screamed in here, didn't I? Okay. So again, I'm working backwards a little bit, but again, all of this just happened this past week. And sorry, this live stream getting put off. I honestly was having some problems with YT, with my Karen Reed content. It keeps getting like, it keeps, I don't know. I keep getting these like content warnings, like I'm talking about something horrible, but I'm just talking about a corrupt case that already happened. YouTube, come on now. I mean, seriously, let's call a spade here. We're all adults, aren't we? This content is not for people under the age of 18. All right. Trigger warning. Everything said in this podcast is my opinion and my opinion only. What else do I have to say, YouTube? I don't know, but here we go. So this is a notice from the judge. Commonwealth versus Karen Reed, notice to appear for continued hearing on February 25th, 2025 at 11 a.m. So that's going to be on Tuesday. The court, so everybody be ready for that. And we'll be here Tuesday night talking about it. The court will reconvene the hearing that began on February 18th, 2025. Counsel should be prepared to address issues related to defendant's recent production pursuant to Rule 14. Rule 14 is that you must produce the discovery to the other side, okay? Especially as the materials produced relate to prior representations made to the court on the record by defense counsel concerning the ARCCA witness. Yikes. Now, ARCCA is that independent accident reconstruction group that testified towards the end of the trial that I think most of us thought was absolutely mind-blowing, that it was going to completely convince the jury, likely in the way that Karen Reed likely was not guilty of manslaughter in the death of Officer John O'Keefe. But we're going to hear from a juror that Turtle Boy interviewed just last week also. There's always a lot going on in this case. And wait till you hear what he said about his impression of the ARCCA expert. Now the fact that there's so much drama around it, it's just kind of like, wow, a little bit ironic. The notice goes on to say, in addition, the Commonwealth referenced a transcript of a hearing on June 10th, and we're going to listen to part of that too, to see where the judge thinks the lies came in. At the hearing on February 18th, 2025, the Commonwealth has provided a copy of that transcript to the defense and the court by close of business on February 21st, 2025. So that was this past Friday. So the judge is saying, how this hearing that happened last week ended was, it was very clear that the judge was super upset. I actually kind of thought it seemed to me like she lost her cool in an unjudgely like way, right? Isn't one of the primary qualities of a judge that they're supposed to be neutral, that they're supposed to be able to handle decisions under fire and stay calm and cool and not show emotion in one way or another? I mean, especially before the verdict is rendered. Like, for example, Judge Darrow showed emotion after Darrell Brooks was convicted of running down and killing and injuring all those people in that parade in Wisconsin a few years ago. But that was after the jury already rendered their verdict. And I understand Darrell Brooks and just the situation of that trial put that poor woman under a lot of stress, and she handled it like a freaking pro. Judge Darrow, you the woman. You're awesome. Okay, but anyway, the judge's panties were all in a bunch about this. So let's see exactly why that was. Now, let's go to Turtle Boy's interview with the Karen Reed Trial 1 juror first to see what he said about his impression of the ARCCA witness. And then if you aren't sure who that witness was, you'll get a little more context here. I was thinking about playing their testimony, but it was really long, and there's so much to pack into this one little episode here. So hopefully this will give you some more context, but listen very carefully. Super interesting. And thank you, Turtle Boy, for letting me use this.
Shape or form.
So,
okay, yeah.
Are you qualified to look at, like, a person's body after they're deceased and determine cause of death? Is that something you're familiar with as an EMT, or is that not something you're trained to do?
That's not my forte. I'm not necessarily, all I know is based on what is provided to me. In
the question here, we're just like a couple seconds before the part that I wanted to show. He's asking this question because this particular juror, his name is Ronnie, is an EMT, okay?
terms of evidence, but I'm not in any way, shape, or form a educated person on pathology.
Well, luckily, there were two experts provided by the federal government from a company called ARCCA that testified, two doctors, and they were...
Again, now these experts provided by the federal government, that means they didn't originate from the defense or the prosecution. That is ARCCA, the accident reconstruction experts, and their CV is like, whoo, impressive.
For the last two witnesses to go. And in order to, they both testified that, according to the physics, the science and the physics, the injuries to John O'Keefe are not consistent with being hit by a car, and the damage to the vehicle is not consistent with hitting a pedestrian. And so those guys are, doctors, PhDs, they do this for a living, etc. And in order to find Karen Reed guilty of manslaughter, you have to listen to the ARCCA experts and say, I don't believe them. So how did...
So again, the ARCCA experts, which is the witness that this whole procedural controversy is about, and could have, the judge said she was gravely concerned about what she learned, and it could have serious impact on the defense. From the lawyers who have weighed in on this case, I understand the sanctions could be anywhere from a hefty penalty to, sanctions with the Bar Association to kicking Alan Jackson, the head lawyer, off of the Reed defense team. So this is really big stuff. So Turtle Boy was just saying that the ARCCA experts maintained that the injuries to Officer John O'Keefe were not consistent with a vehicle accident. Now, this is what the juror thinks about ARCCA.
8 jurors reached the conclusion that those guys didn't know what they were talking about.
It was as a direct result of the Karen was there at that time, and John was there at the time, and it was believed that John died there, therefore, right, at that location, and therefore it seemed like, and everybody, all the witnesses were suggesting that he was never inside the house, and as a direct result, the assumption, or if you connected the dots based on the evidence that was provided to us, it seemed like there was some sort of collision with the car, and therefore there was damages to the vehicle. And with the damages to the vehicle, and that both individuals were there and present, that the cause must have been, or somehow, some sort of involvement by Miss Reed. So that was how they all arrived at.
But how did they reconcile? Was the ARCCA testimony brought up by the people that thought that she was not guilty? Did they? I'm sure somebody in that room must have said, but these experts are telling us that that's not possible. And what was the answer to that? Like, did people say that that these guys are bullshit artists, that they're fake doctors? Like, what was the reason not to believe them?
I think the major rebuttal was, we don't know. And that was the other thing. It was very ambiguous on why these individuals were testifying. And so there was a question in the group on their essential integrity, in terms of, were they there as a direct result of somebody else trying to steer us in a different direction and confuse the jury.
Okay, so he just said right there. Now, when the ARCCA witnesses testified, the defense had to bring them on the stand and question them very carefully, because they were independent witnesses. Again, they weren't brought in by the defense or the prosecution. So it was much less clear than with any other witnesses as to why they were there. Although those of us who are not on the jury, right, who are watching the coverage of the trial, are getting the whole backstory. And like Jay May was just saying, and I totally agree with her, these ARCCA experts, their testimony was absolutely pivotal. I'm like, oh my God, if these federally provided independent experts are saying that John O'Keefe's injuries are completely inconsistent with a vehicle accident, then Karen Reed didn't hit him with the car. Plus, I'd already thought that anyway, just by seeing the injuries and the abrasions on his arm that to me look like cuts, like knife slices or dog bites for sure. And the medical examiner described the rest of his body, as far as bruising or any other mark going, as being pristine. So the only injuries to this man on his body that were perceivable were the back of his head and these injuries that looked like slashes or dog bites on his arm. So when these ARCCA experts testified, I was already almost at the decision in my own mind, in my opinion, allegedly my opinion only, that Karen Reed was innocent. But once they testified, I was like, oh, slam dunk, it's in. The state is done. She's innocent. I was like, the jury, all 8 of those people have to agree the same. Or 9 or 8 in Massachusetts. I can't remember. Let's hear. He's going to say a little more here.
So it wasn't sure if it was insurance. It wasn't sure if it was, whether the Reeds were doing it, somebody else was doing it, or yourself was doing it to bring this group to try to testify so that it would sway the jury in one direction or the other. And that, I think that was one of the things that was, again, unfortunate, because I guess it cannot be said, or didn't want to be revealed to us, what were the circumstances of why those individuals were testifying, other than they were testifying for the defense.
Because now, obviously now that the trial's over, that they're not even defense experts, they're FBI. They were available to both sides, and only the defense called them. But it seems like the conversation in the room went, and they said, some people were suggesting maybe they were the insurance company, of course, because of course an insurance company would benefit from not having an automobile collision. Obviously, they wouldn't have to pay anything out. Or me, how did people thought I paid the ARCCA guys? That's wild.
Like anybody, somebody was trying to, again, to try to sway
Now, Turtle Boy is involved because he has been advocating for Karen Reed's innocent and for justice in this case. He's been there on site at the courthouse, and he is being accused of harassing the state's witnesses. He has his own attorney. There's a whole civil suit involved. So that's how this guy Turtle Boy is involved, if you don't know.
The jury in one direction.
Can't make this shit up, man. Look at him. This must be a hard interview for him because he is gung-ho more than anybody else on Karen Reed's innocence. And look at the house. Is the house behind her the house where his body was found? I believe it is. Yeah, I think it is. Albert's house. I think it is. Yeah.
Versus the other.
I'm not that powerful. I promise you. I can't afford those guys. But so that's basically the reason that they came up with they said they heard all their testimony, and then they said, nah, those guys are just probably paid off by the insurance company. We're going to disregard everything that they said.
Yeah, and one of the other reasons is because there was the other testimony of the individual from the dog bite expert and all of the other things that the defense was trying to bring up that, again, wasn't sure if it was just to try to confuse or sway the jury in one direction versus the other, or create a jury which was created reasonable doubt, and therefore the vote had to be in one direction versus the other.
So it sounds like what you're saying is that some of the jurors in the room were saying that all of this defense third party culprit thing, a dog biting John, this is all bullshit. This is all a smokescreen, and all these people, this dog bite expert they're bringing in, this is all a distraction from the fact that Karen Reed ran John over. Is that an accurate portrayal of what people were saying in that room?
That is correct.
Wow. Okay. So in order to believe that Karen Reed killed John O'Keefe, you have to believe that, and that John O'Keefe didn't go inside the house. You have to believe all of the McAlberts who testified. And so am I correct in saying that they found the McAlberts to be convincing witnesses and truth tellers?
Correct. And I will say that that's to some respect, not only to say it's correct, but also to some respect, because there were some individuals who just looked at the facts. Again, the clear fact that Karen was operating a vehicle and drove the vehicle.
Hot damn. Now, operating a vehicle makes you guilty of manslaughter? Dang, jury, dang. I hope she gets a different jury next time.
Vehicle to that location, 34 Fairview.
Mm-hmm.
And then ultimately, John O'Keefe lay at rest and died on essentially that address. And so everybody else is saying that he never entered the premises. Therefore, she must be at fault because he clearly did not just injure himself there. So,
did anybody suggest that maybe the McAlberts are not being truthful?
Yeah, maybe.
That maybe he did go inside. I assume somebody in the room, the not guilty voters, must have said that these people are lying, obviously. And what did people say to that? I mean, did some people believe at least that they weren't being honest?
I think the individuals who believe that she was not guilty was because of the mere fact that it was not adding up. So the injuries to John O'Keefe ultimately did not add up to the damage to the vehicle.
Mm-hmm.
And what ultimately injured him was, or led to his death, was a injury to his head, which was not very clear that type of damage could have occurred on the vehicle. And there was no damages on the vehicle that would indicate that kind of situation. So for those who were skeptical, that's what they were looking at.
Yeah, the Commonwealth alleges that that his arm, I still can't believe they said this theory, that the arm was out, and that the arm is what caused the taillight basically acted as a knife and just sliced his arm up. and then caused him to spin and then land 30 feet on the grass. And the gash in the back of the head came from hitting the grass, which they said was so hard that it somehow caused a gash in the back of his head. People really believe that?
Yeah, I mean, I don't think a lot of people in the room, some people who were experts in science, right, and physics, or have some knowledge of physics, necessarily believe that as the case, given the circumstances, that it was not very clear. But again, some individuals just believed at just the circumstance that Karen and John were there at the same time, and John ultimately was killed.
And the text stream data is what you mentioned a lot last time, and you said that was what the guilty people really stuck to, was the text stream data. What was so convincing about the text stream data?
Okay, all right. So I'm going to stop that there. This is so interesting. I just kind of want to listen to the rest of it because I just thought this was the most interesting interview, but I'm going to stay consistent with the topic at hand here. So McJ, thank you so much for the super chat. I'm so glad that you're here. I know you're really into this case because it is so freaking interesting. So now let's go to, all right. Let's go to watching some of the pretrial proceedings from last week where this all came up. Now, we're also going to be looking at another issue that came up at the beginning that has to do with more possible POLICE corruption. Is that better for you, YouTube? Is it? I hope it is. And then we're going to skip through kind of some of the mundane stuff in the middle and then go to the end where this topic is introduced and the judge kind of bugs out. This hearing was supposed to be on a complete different topic altogether. And you'll see at the end, one of Karen Reed's attorneys says, well, yeah, Judge, can we, at least allow, this other counsel to move forward with what he has planned today? She just goes, no. And then everyone sits down. She was like real serious about it. All right. So let me bring this in. And again, guys, don't you think that's really, what do you guys think about the testimony from this previous juror and his opinions about the ARCCA expert? What do you guys think about that? Anyone in chat want to weigh in on that? Okay. Edward says, where does double jeopardy, where does that come in? Does it mean you can't be convicted of the same charge twice, or you can't be tried for the same thing twice? Well, you know what? In the beginning, when this all happened, obviously this doesn't follow double jeopardy, or the judge wouldn't have ruled that way. But I guess when there is a hung jury and no verdict is rendered, there can be a retrial. So that's the best way to say it. The way you asked the question, I'm not sure if I could give you a detailed enough answer to satisfy people that would be totally accurate. So we'll leave that to lawyers. Hey, Pepper, how are you doing? Nice to see you. Let's see. Yeah. So McJ says Milani, the judge, or MSP, Massachusetts State's Police, or even judges could be FBI target of investigation. Bev needs to just deal straight in this case. That's a really good point. So for those of you who don't know, this case, the investigation, we believe, but we're not sure. But there has been an FBI, maybe I shouldn't have said that out loud. Sorry, YouTube. Investigation looming over this case since during the beginning of trial 1. Guys, this is so mind-blowing. Usually an FBI investigation into a case is not going to be active while there is actually a jury trial going on, because these branches of government are supposed to remain separate, right? So it's just crazy because they don't want the FBI to be putting their finger on the ultimate verdict of the case. So this case from the very beginning has had so many unprecedented quirks and events and happenings going on. It really is absolutely mind-blowing. And I hope you guys are all going to join me to watch the second trial in detailed motion, because it's going to be crazy. Hey, Warning Label Nina, great to see you. Thanks for being here. Warning Label Nina hopefully is going to come on with me again to talk about the Idaho case again really soon, because she is Awesome. Everyone go check out her channel. All right. Okay, so here we go. So this is Alan Jackson again, the amazing, I believe he's an amazing lawyer, in my opinion, that could be facing some kind of serious sanctions for the issue at hand that we're talking about right now.
Now you're talking about something that looks like a much more formal system called the Department.
All right, gotta go back.
Okay. Who's arguing this motion for the defendant?
I am, Your Honor.
Okay.
Thank you, Your Honor. My comments will be relatively brief. We filed this motion basically because we had no choice. We were following the court's instructions, meeting with Mr. Brennan after court, the last hearing, which was the 6th, about the download of the video footage that apparently has been stored, or at least we believed at the time last week, had been stored on some sort of an iCloud. We were told that this was an account of a retired detective, as explained by Mr. Brennan. We met after court. Mr. Brennan told us that we did not need, we told Mr. Brennan that we did not need an expert to fly out and go through all the machinations of having someone present. If all the information was a download from some iCloud account, unnamed iCloud account, as long as that was videotaped, we were fine with it. And that was basically the agreement. That was the information that we had at the time. We were predicating that on a conversation that we had with Mr. Brennan in January, I think it was January 22nd. He indicated that he went to Canton PD the same date, and the court will recall December 12th was the date of what I've referred to as sort of the wild goose chase, that we sent an expert out, etc. That same afternoon, apparently Mr. Brennan went to the Canton Police Department and found out that there was, in fact, additional video.
Mr. Brennan is one of the district attorneys for the Commonwealth of Massachusetts.
Which was news to us. He claims that it was news to him. And putting aside how odd that is, after 3 years of being told we have everything, he went on to explain in very specific form in a telephone conversation that he had met with a retired detective. At the time, he could not remember the detective's name. He said that the detective believed that he kept a copy of the January 29 video that we were looking for, and that he said that it was on a work computer's iCloud account. Mr. Brennan said that they intended to download it from the iCloud, turn it over, and that's the point at which we said, if you don't mind, just hold on that, because we're litigating ultimately this issue, which was the litigation we had on February 6th. So we had the hearing. The day after court on the 6th, after we reached this agreement that the iCloud would just be downloaded and videoed, we received an email from Ms. McLaughlin, and that changed the parameters of what we had believed and what we'd been told by Mr. Brennan. And it sounded more like this. The Commonwealth changed the story from some work computer iCloud account to the footage was being stored on what's called the, quote, department's video file system. It's very different than a retired officer's or a retired detective's work computer's iCloud, which is what Mr. Brennan believed at the time and what we were led to believe at the time.
Now, the essential point here is the defense has been calling out misrepresentations made by the state and made by the investigators, including some huge ones, some grave mistakes or intentional happenings, that if it were not for them, Karen Reed probably wouldn't even be on trial. You know, the defense keeps calling that out again and again and again and again and again and again and again since day one of this trial. This whole thing, in my opinion, I'm sorry, I try to reserve my opinions on, you know, cases, especially as they're going down, as much as I can. But this reeks of soaking, like replete, saturated corruption.
Ms. Little sent an email saying, I'm confused. Now you're talking about something that looks like a much more formal system called the department's, the CPD video file system. So we want, that's fine, no problem, download the videos, but we want the metadata and the log files that are associated with that. If it's on a formal file system, it's going to have metadata for the upload, for any access to the data, and for the download. We want the metadata and the log files as well. And that's the key entirely to the audit trail that we're interested in. Historically, we have been asking for videos, for all this video surveillance to be preserved and provided for about 3 years. And this has been one of the centerpieces of this litigation. When we asked for that additional metadata and the log files, Mr. Brennan, in my opinion, took an odd position, which is, nope, we had an agreement. We met right back there in that room. We said that you could videotape the download of the videos. You don't get anything else. If you want anything else, go to court and file a motion, which is why we had to file this motion. We don't think that it was necessary. This is metadata that is literally in the Commonwealth's possession as we speak. They have it. We're entitled to it. It's simple. That's all we're asking for. Mr. Brennan referred to the video files being placed on Canton Police Department detective file, which is yet another name for where this mysterious video may be held. And we said, it's easy to get the metadata. Let's just do a quick forensic image. It'll take less than a day. And all we want is the metadata for the 24-hour period, 23 hours and 59 minutes to be exact. And we don't need to file the motion. The first question I have is, why would the Commonwealth even object to this? It doesn't seem like something that they would want to object to. This is in their possession. They know that they've got it or they've got access to it. Why wouldn't we get it? These videos, again, have been a pain point for this case. These videos have been a pain point for this case for time immemorial, since the beginning of the case. We've been demanding that footage from 2022, January 29th, 2022. We were told explicitly on December 12th that no footage existed when we went out and had an expert look at the DVR. Their analyst actually called Mr. Brennan when our expert, who was on the floor at Canton PD, asked, are there any original files that are in the possession of Canton PD? The analyst went, I think her name was Colleen Crawford. It was Colleen Crawford. She went and called Mr. Brennan, according to our analyst. Mr. Brennan then informed Ms. Crawford to tell our expert, get it from the defense. If you want original files, get it from the defense, knowing full well that we don't have it. If we had it, we wouldn't be there. And then it was that same day that miraculously the Canton Police Department revealed that, in fact, it did have some video footage on this either iCloud or video system. We take the position very clearly that this is Brady information. It's exculpatory information. The audit trail is also Brady and exculpatory, because the audit trail will tell us information that we won't otherwise have from the raw video. How did the footage end up on the system? When did the footage end up on the system? Who put it on the system? How many times has it been accessed? Has it been accessed at all? Has it been altered? Has it been manipulated? Has anything been deleted? Those are all data points that will be embedded in the metadata and the log files. The only way to answer those questions is for us to get it. That's all. And that's all we were asking of Mr. Brennan. We are surprised that he would object to that, because we would think that, in point of fact, he would want those same data as well. Mr. Brennan made a point of saying, when he first came on this case, look, we want to give Ms. Reed a fair trial. We want to be as transparent as possible. And my hope is that was not just lip service for the media. I don't know why the Commonwealth would object to this. There's no reason to object to it. They have it. We want it. And now we're asking for the.
Okay, now just for some context here, the state has already been extremely shady with, or the investigators, one or the other, or both. Now, understand that in the Commonwealth of Massachusetts, the state police are housed right in the district attorney's office. They answer directly to the district attorney. Now, this is different than how it is in some other jurisdictions in some other states, but in the Commonwealth of Massachusetts, that's how it is. So the state police and the district attorney's office and the prosecutors are very closely intertwined, and maybe like in an incestual way. I don't know. I mean, that's up to you and that's your opinion. But remember, there is the investigators, or the district attorney's office has a very shady history of presenting video footage in discovery or for the trial. For example, we watched this during the last live stream, that video footage from the Sally Port at the Canton police office had the video inverted. So it looked like we were looking at the passenger side of the car when head detective investigator, disgraceful, State Trooper Proctor was there, having to do with him possibly extracting pieces of Karen Reed's headlight to plant at the scene, where really we found out just during the course of the testimony the video was inverted. So we're really looking at the driver's side and not the passenger side. Let's just take a look at that really quick.
Garage door are reversed.
Okay, guys, and the reason this is
Oops.
is let me go back a little.
Last night.
Yep.
And you talked about the reaction to it. Can you just go back a little bit and do that again and what our producers noticed yesterday?
Sure. So the prosecution showed this video, the original video, to the court yesterday. And then, there was some reaction and hubbub at the defense desk. Then there was a sidebar, and they were almost giddy at the defense desk about this. And Karen Reed actually turned around and mouthed, and
Whoops.
don't need to be, I have the wrong side. It's the wrong
Whoa. Sorry.
side. And so they had the sidebar, and then our team here took a closer look at what the video showed. And one of the first things they noticed is that the word police on that antique car and then the number 4 on the garage door are reversed.
Okay, guys, and the reason this is so that's enough of that. I just wanted to make sure that those of you that weren't totally familiar with that got a little taste of that. Okay, so I'm going to bring that pretrial hearing from last week back into the stream. And of course, what's going to happen next after Alan Jackson just made his argument, of course, Brendan's going to come up for the prosecution and he's going to say, oh, no, that wasn't the case. Everything is opposite of what Jackson just said, of course. So that is still yet to be determined. But now we're going to move forward to the ARCCA issue. Let's see, I'm not exactly sure where it starts, so please bear with me. That's when the judge leaves, it comes back. So let's see, let's get to where Brennan starts here. Okay.
Connection with this case. We find the Commonwealth's response to this request.
Make logs up that don't exist. They're not going to make a record of something.
Okay, so now he's just talking about his response to what Alan Jackson said.
These statements that would be helpful for the defense. So we have an affirmative obligation under Graham. In fact,
I don't know what's up with everybody who is, acting as a lawyer for the prosecution here. Can't y'all speak up and be a little more animated?
I had a conversation with defense counsel.
Let me move forward. Okay.
All correspondence available to me for Rule 14 materials and provide it.
All right. Any follow-up, Ms. Little?
No, thank you, Your Honor.
All right. So I'll take that under advisement. Do you have that Rule 17 paper number?
Okay, I think this is where it starts.
Your Honor, my purpose is not to deprive the defense of an expert or deprive the defense of an ARCCA expert in this case. But there has to be a minimum requirement of reciprocal discovery and discovery before a party can call a witness. It's not enough to say that the witness is helpful or unhelpful. There has to be full disclosure when calling an expert. It's interesting that the defense's position is that the information is unavailable to them, and that since there's been a voir dire and trial testimony, that should be enough. Well, what the government worries about.
Just by the way, thank you so much, Honey Bun, for gifting 5 What's the Obsession membership. So everybody who's now a new member, congratulations, welcome. I'm going to be doing 2 members only events this week. I promise. One's going to be a video, one's going to be a live. So that's awesome. Hope you can come. And congratulations. Please thank Honey Bun.
Is that there is other things that are relevant, like compensation, promise, reward, inducement, whether there's collaboration between one side or the other and that expert witness that they don't know about and can't ask about, that there's some type of bias or favoritism that the expert might have towards one side for whatever reason. So if that information is not disclosed, then it is not only an impediment, it creates a position where it is an unfair examination. It's not the ARCCA witnesses that I have the issue with. It's the fact that I don't have adequate discovery. If the defense is going to be a proponent of those witnesses, they have obligations, Rule 14 obligations for basic discovery. Now, I wasn't at the last trial, but I've read the transcripts. And on June 10, 2024,
Now,
You
wait,
asked the
before we
defense-
get into the juice here, because we're about to get into the serious juice, I just want to also read this comment from Jay May for those of you that aren't aware of just, my God, the many facets of corruption and impropriety. In this case, Jay May says, Bev, Aunt Bev, people call her, that is the judge. Bev's lawyer brother defended an Albert. Now, the Alberts is a family of whose home Officer John O'Keefe was found deceased in the early morning hours of January 29th, 2022. So the Alberts are big players in this case. So Bev's lawyer brother defended an Albert in his hit and run case. She should have recused. Amen, J. May. I believe in the state of New York, she wouldn't have been allowed to preside over this. I'm pretty sure of it. That would have been a conflict of interest enough to rise to the level of, of the bar getting involved if she didn't recuse herself, but she should have just recused herself like a big girl.
About ARCCA, and it was represented, these experts were hired by the federal government and they provided a report to us pursuant to a TUI request. It was specifically outlined and ruled that they could not prep with us for trial. Could not prep.
Okay, I'm so sorry. Again, one more time, Jay May or McJ, I was just saying that in the Commonwealth of Massachusetts, the state troopers department is housed within the district's attorney's office. There's a very close, almost conflict of interest, too close for comfort relationship between the two. Now, usually law enforcement, is somehow under the wing of the prosecution, the district's attorney's office. But, ideally we want them to be neutral and to just speak the truth and speak to what the results of their investigation yield, rather than to be, as you're saying, buddy with the prosecution. So really good point. Yeah, exactly. All right, I'm going to keep playing and not interrupt now.
With us for trial. And so Your Honor said, so I am to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand here. And the answer, that's essentially it. We've spoken to them only for purposes of coordinating their testimony and their background. We've not been able to interview them regarding their findings, which are outlined in detail in the reports that both sides have. Your Honor said, see, I don't see that as being the report. I don't see that as being detailed. It leaves a lot of questions as the gatekeeper as to what they can testify. And you have not complied with your Rule 14 obligations. And the defense says, we can't, Your Honor. And Your Honor said, so you can't, but you haven't. So I'm left with that you have not complied.
So where in the transcript is this?
On page 2812 and 2813 of June 10, 2024. Now, having some familiarity with the federal government, it seemed to me, based on my limited experience, there was much more to the story. So I called the federal government and I tried to encourage them to provide full discovery so that the experts could testify. I was resigned to a TUI letter. I've been down that road many times. It's a dark road that never sees the light of day. So I filed a TUI letter, comprehensive TUI letter. And it was delayed. And over a long period of time with requests and deadlines, I finally received a response that was unresponsive. And it was striking that it wasn't noted as unresponsive, just when I read the materials, and Attorney McLaughlin actually identified them. They didn't respond to our request, so Attorney McLaughlin wrote back. And then we got new materials, just some. But these materials are the very reason why the defense should not be able to call witnesses without giving full discovery. Having not been at the last trial and reading the transcripts, I only
I'm so sorry. Sorry, I was on mute. So I'm sorry to interrupt again, but Honey Bun makes an important point. Let's all forget here what the cops have done in the past. RIP Sandra Birchmore. That case is absolutely effing unbelievable. And just quick, for those of you who don't know, this young woman, Sandra Birchmore, got involved in this, police mentorship program when she was 12. This here we have the sheriff's camp or something. And this officer ended up having sexual relationship with her when she was 15, underage. This continued for years. He eventually got her pregnant. And then while she was pregnant and he was married and his wife was pregnant too, by the way, she suspiciously died and it was called a suicide. But when you look into the investigation, it was all kinds of corrupt, and there's clear evidence that it was at the officer's hand that this poor young woman, Sandra Birchmore, passed. And rest in peace, Sandra Birchmore. Really important point when we're looking at this case. Corruption everywhere.
We have a flavor for the last trial. So there is email correspondence between the defense, not only the federal government, but the ARCCA witnesses themselves. A recent request for their appearance pursuant to TUI, which I have no issue with. But if we look back earlier in the relationship, what we see back in March 22nd, 2024, is that there are conversations between the defense, Attorney Jackson, and Daniel Wolf, who's one of these ARCCA witnesses. Thank you so much for taking the time to get on the phone with me this morning pursuant to our conversation. Please feel free to forward an engagement letter to this email address. I will get that countersigned and return to you forthwith, along with your retainer as required. The Commonwealth, as I understand it, was not aware of any promised rewards or inducements or payment. They relied on a reciprocal discovery order of this court for that information. Response: hi, Alan. Subsequent to our conversation on Wednesday, the U.S. Attorney's Office asked we pause any further conversation until we received additional information from their office regarding how our involvement will move forward. Now, it's not the opinion that troubles me, it's the relationship, and Commonwealth should have an even playing field. Saturday, June 22nd, Daniel Wolf writes, Alan, I spent some time this morning putting together a brief outline of my qualifications, also attached my D&T list. I obviously won't say what the response is verbatim, but I gave you a general sense of what my response would be. Again, I thought your questioning during the voir dire was fantastic, so please feel free to make whatever changes you feel necessary. Now, this isn't information provided by the defense in reciprocal discovery. This is information provided by the federal government after numerous requests, TUI requests, and an insistent, the best I can, to get as much information as I can. We then are provided an outline of questions and answers for a direct examination. The Commonwealth did not have the luxury, the privilege, did not even know that there was an outline that was being disseminated by this totally independent witness who took no side other than that of the truth. What follows from this outline is then the outline with remarks from this independent expert who knows nobody. So we see in the margins in the notes, this fair-minded objective witness says, so not being able to inspect the vehicle is something that's not uncommon in your line of work. And he writes, absolutely not. And then he comments, not sure if you want to put this somewhere in the direct examination. I have a feeling they, the Commonwealth, are going to argue I didn't personally inspect the vehicle. I had enough information from the material I reviewed, so it wasn't necessary. Need to show the jury it doesn't matter in this case.
What's the date of that?
It's not dated. It's not dated. The TUI request is a recent February response, but they send random documents. There's no real accounting. Now, I'm not saying that undermines the conclusions of ARCCA, or not. I'm not saying they're not qualified witnesses, but it certainly shows some bias. I've turned over a lot less in this case than this. Another comment. Would be fair to say because you had a lot of nighttime visibility work, your cases frequently involve pedestrians. Yes, unfortunately, there is a direct correlation between the time of day and pedestrian fatalities. Statistically speaking, most pedestrian fatalities occur during the evening and night hours. That would have been nice to have. So my specialty in the area of lighting and human factors results in a lot of my cases involving pedestrians. Pretty important stuff in this case. And then he comments, if you don't want me to say this, that's fine. That's fine. Shh, don't tell them. Have you qualified as an expert in court before? Yes. I realized my testimony, I said it 20 times when you asked how many I've been qualified. I misinterpreted the question. My fault. 11 trials, 7 depositions. Not sure if you want me to clear that up. I don't know if it was ever cleared up. And then a bill from ARCCA to the defense for $23,925. That's not trample. That's not trial by ambush. That's getting duped. So I didn't know any of this, but I've tried a few cases. I've been around the federal court a little bit. I know how it works. Sometimes parties pick sides. It creates an imbalance and unfairness, and then it allows the ability to one side to use ghosts. They create illusions and shields and say something's there and something's happening, a federal investigation and this person, and then this happens. I don't care if the ARCCA witnesses testify at trial. I don't care about their opinions, but I care that it's unfair, imbalanced, and hidden. And the Commonwealth, like the defense, is entitled to discovery. So if they can produce the discovery, I'd welcome ARCCA.
All right, I'm going to take a recess before the response.
All right, please.
Okay, so there you see the judge abruptly says she's going to take a recess. Okay, now, so what he was saying, and I know, guys, everybody who is, arguing on behalf of the prosecution is like, it's like watching paint dry. Somebody said, it was Turtle Boy in that interview with a juror when he said that, he was talking about Lally's voice is like a dial tone, which made me laugh out loud. I thought it was pretty funny because it's pretty damn accurate. But what he is saying is that the defense did not provide the proper discovery for their conversations with that independent federal witness, ARCCA, which was that pivotal witness that said that Karen Reed's Officer John O'Keefe's injuries were absolutely inconsistent with a vehicle accident. And then, we listed that jury say that they were really confused about that, what we believe were those two very powerful witnesses from ARCCA that made up the minds for a lot of people that Karen Reed was innocent. That juror said that a lot of people discounted them because they were confused where they came from because the defense had to dance so carefully around the issue of the witness because they were not produced initially from the defense or the state. But the prosecution is saying that they did not properly disclose their communications with that ARCCA expert that they paid them essentially, and that they misrepresented their relationship with ARCCA and their communications with them in a June 10th hearing that we're going to listen to in a minute. But first, let's watch Judge Bebb, in my opinion, kind of wig out. And please watch carefully because I really, really, really want to know your opinions on her conduct and demeanor here when she comes back. All right, everybody, get ready. Here comes Aunt Bev.
Cell phone off, put away.
All right. So the Commonwealth just provided the court with information that causes me grave concern. The implications of that information may have profound effects on this defense and defense counsel. So for that reason, I'm going to suspend today so that when we meet again to address these issues, all affected will be appropriately prepared. So I'll see you a week from today at 11 o'clock in the morning. You can tell me now if that is impossible for you. And where Mr. Brennan, where the federal authorities have been kind enough in the past to allow me to have copies of everything, would you be kind enough to call over there or check with whomever you were dealing with to see if I can in fact get a copy of everything that you just read?
I can, and there's a brief chronology I think Your Honor should be aware of. If I could add that right now, it would take me less than a minute. The chronology is December 4th, we sent another tour request, 2024. January 6th, we
Wait, guys, it's so funny that you said that, Cuffy, because I was just thinking about what I was going to say to you guys, ask you as a question after that. And I was going to say, what do you think of her breathlessness and her uneven tone and physicality there, which Jay May also then said her hands are shaking. So I'm just going to go back, watch that when she comes out. It's only like 45 seconds long. Again, I just think I feel like she lost her shit. She couldn't even compose herself to come back, to the bench. Get with it, Bev. We're going to start that GoFundMe for your new wig. Jay May, that was hilarious.
Cell phone's off, put away.
All right. So the Commonwealth just provided the court with information that causes me grave concern. The implications of that information may have profound effects on this defense and defense counsel. So for that reason, I'm going to suspend today so that when we meet again to address these issues, all affected will be appropriately prepared. So I'll see you a week from today at 11 o'clock in the morning. You can tell me now if that is impossible for you. And Mr. Brennan, where the federal authorities have been kind enough in the past to allow me to have copies of everything, would you be kind enough to call over there or check with whomever you were dealing with to see if I can in fact get a copy of everything that you just read?
I can, and there's a brief chronology I think Your Honor should be aware of. If I could add that right now, it would take me less than a minute. The chronology is December 4th, we sent another tour request, 2024. January 6th, we filed our notice of intention to exclude ARCCA experts. January 30th, 2025, the United States Attorney's Office sent a response to both ours and the defense requests. Without any prompting, on February 6, 2025, the defense and the prosecution received an email from the U.S. Attorney's Office saying that the contract had ended with the ARCCA experts and that if either party wanted to engage, the original materials are still protected. This was a change in position about whether a party could engage. On February 11th, we filed the motion to exclude. February 13th, the defense provided us the emails that I read. February 13th, 2025, I think I said the federal government. It was the defense. February 13th, 2025, they sent us the emails and the direct examination outline. We reached out to the federal government again because I was curious about the change in position on February 6th, that the contract has ended, but that parties could contact ARCCA. Obviously, the Commonwealth is in no position to contact ARCCA because that would naturally preclude the defense from retaining them. So we've refrained and we will not reach out to them.
All right, so the information that was provided to you, not from the federal government, I'd like a copy of before you leave the courthouse today.
Yes, Your Honor.
All right, 11 o'clock a week from today.
Your Honor, is it possible to move it one day to the 26th instead of the 25th?
It would have to be at 9 o'clock in the morning.
Your Honor, if I may hand up the discovery that was
Thank you.
provided by the defendant reference by.
Oh, great, thank you.
Is there any way she was responsible for today?
We can do the afternoon of the 25th if the morning doesn't work.
The problem I have, Your Honor, is I've got a hearing on the 24th. I have to fly on the 24th, even to be here.
So you can be on Zoom for this if you want, Mr. Jackson.
I'd rather be here, but I have to accommodate whatever the court's calendar is. I have to accommodate the court's scheduling. If we can do it live, I'd rather do it live, but I will accommodate the court's calendar.
Are all parties available at 9 on the 26th?
I'm not.
Ma'am, just a moment.
Yes.
Your Honor, we'll accommodate the 25th, one way or the other.
All right. So we'll see everyone.
I'm sorry. Just on behalf of Mr. Alessi, is there any chance the court would entertain the motion that he's doing today or no?
No.
Okay.
All right, 11 o'clock on the 25th.
Thank you.
All rise for the court, please.
All right. Now, regarding the 3 experts from ARCCA. So I've read that report. I can't tell who does what or what the basis of their opinion is. So what have you provided?
Your Honor, we've provided everything that we know. We've mentioned to this court at sidebar, these experts did not arise from us.
I understand that.
These experts were hired by the federal government, and they provided a report to us pursuant to the TUI request, and it was specifically outlined that and ruled that they could not prep with us for trial.
So
it was specifically outlined and ruled that they could not prep with us. I don't know by who. It doesn't sound like it's from Judge Cannoni because she wants them to provide the Rule 14 discovery that they can't. So it seems like the federal government told them they couldn't prep with them. So they're not violating. It doesn't seem like if they did prep in violation of whatever that rule was, it doesn't seem like they violated a court order, which again changes kind of the sanctions available. So that's what I'm trying to figure out here.
TUI request, and it was specifically outlined that and ruled that they could not.
So pursuant to the TUI request, it was specifically outlined and ruled that they could not prep with us. Again, this is June 10th of 2024.
Prep with us for trial.
So I'm to believe that the defense is calling 3.
Oh my God. So I've been muted that whole time. Oh my God. I see what happened now. It was on my computer. I'm so sorry. So, okay. So what we're watching now, I have to say this all over again. I'm really sorry about that, guys. I guess I should have noticed where you guys said muted. So this is a June 10th hearing. So we're looking at the defense's initial representation of the issue in question. The issue that Bev's panties are all up in a bunch about, that has her hand shaking and her all breathless and her wig almost falling off her head. And I was saying that I found this on the Lawyer You Know channel, Peter Trago. So yes, this is a lawyer you know, because I couldn't find it just in the raw footage because there's just so much of it. So thank you, Peter Tragos, for having us on your channel. So, I think, he just presents his channel as being, hey, listen, I'm a lawyer and I'm just trying to give you the legal perspective and answer the questions about these cases that y'all are interested in that you might not be able to answer without a legal expert. So, I do give him a lot of credit for that. His channel's killing it. He's great. I think he's awesome. Yes, and he is easy on the eyes, isn't he? So I'm so sorry about that being muted. All right. So again, this is a June 10th, 2024 hearing, and the defense's representation of their relationship and communication with this ARCCA expert, that federal witness that was not brought in by either the state or prosecution, that is so controversial now with all of these second pretrial hearings are about, and why that hearing, that notice of hearing I read in the very beginning, it's telling everyone they better damn be in court on the 25th, this Tuesday, because something is going down that Bev says could greatly impact Karen Reed's defense. She has grave concerns over it. Those are her words. So we're going back to the beginning, to their initial representation, and asking, what's up, Bev? Why you got a problem with our boys? And Karen Reed.
Witnesses that you've never spoken to and putting them on the stand here
That's essentially it. We've spoken to them only for the purposes of coordination of their testimony and their background. That's it. We have not been able to interview them.
So coordination of their testimony and their background. I think I missed that the first time, but when you talk background with somebody, that can be pretty broad, right? So what do? Well, I look at cases like this. I do line of sight stuff. I do accident reconstruction like this case. So background and coordination of their testimony is more than just coordinating their schedules, you know? So again, words are important. And when you get to stuff like this, the lawyers are going to have everything ready to argue what every single word means, that you did not lie to the court. You didn't misrepresent anything, that you did everything you said you were going to do when you said you were going to do it at the time you said it. That's important too here.
Regarding their findings, which are outlined in detail. We have not been able to interview them regarding their findings, which are outlined in detail in the reports that both sides have.
So they were not able to talk to them about their findings. The judge is going to disagree that the reports are detailed.
See, I don't see that as being, the report, I don't see that as being detailed. It leaves a lot of questions as the gatekeeper as to what they can testify to.
Well,
and you have not complied with your Rule 14 obligations.
We can't, Your Honor.
So,
we can't.
So you can't, but you haven't. So I am left with you haven't complied. So we need to get everybody here for voir dire. They can testify in voir dire, right?
Yes.
We need to do that well in advance of their testimony.
Okay, that's fine, Your Honor.
All right.
Yep.
And now tell me about this ER doc. Is she an ER doc?
So first off, what did that sound like to you? Because to me, it sounded like we just solved all these problems. We have just cured all prejudices. Because as of June 10th, there has been no prep. There's been no email back and forth, no conversation. That happened June 22nd, according to Hank Brennan reading the emails. We don't know specifically what was in the outline or the notes, but that was June 22nd. So at this time, on this date, it seems like everything that was said was true. And any discussion, any issues, anything that happens after this is different than what happens here. And that's all really important.
I haven't seen.
Also, by the way, it's all been cured because they fix all of the discovery issues with the Rule 14 by the voir dire. That's how you take away any prejudicial effect so that the Commonwealth knows exactly what's going to be testified to and they can ask any question they want on cross. It is to cure the prejudicial effect. We saw it happen in Sarah Boone. We've seen this happen in many cases. Voir dire basically cures discovery issues.
She's not a pathologist,
Well,
correct?
she's a pathologist, but she has
They're talking about Russell just for a second, then they get back to ARCCA.
lot of experience in an ER, which is why she has the experience of having seen dog scratches and dog bites and dog attacks.
All right. So this is not somebody that was involved in the federal investigation, correct?
Correct.
All right. So you need to provide immediately. I want to, and we want the other folks up here from Pennsylvania this week as well.
We'll make those calls.
So we need to pick a day. How long do you expect the voir dire of each of these witnesses? If in fact the defense has not spoken to these witnesses from Pennsylvania about the nature of their opinion, you must want it too, to be able to question them. How long do you expect?
And prior to.
And guys, what we're looking for here is we are trying to see if the defense did in fact make some misrepresentation in court to the judge, because ostensibly that's what our panties are all up in a bunch about. And everyone, if you can, please, please, please take a moment to hit like. These Karen Reed videos have been getting smacked down and definitely unmonetized for me by YouTube, and I don't know why. So I would like to send a message to them the best that we can. So please, please take a moment and hit like. I would really appreciate it.
Voir dire, we have nothing that says they've spoken to them, right? The email correspondence was after voir dire because he complimented Jackson's questions during the voir dire.
respect to voir dire of each of these witnesses to take. I went and told the jury last week, last week that we were going to get them this case by the end of the month based on your representations, which included voir dires. It looks like at least a day of voir dire hearings here.
Yeah.
Yes.
Of course, at least with regard to the ARCCA witnesses, that's my co-counsel's bailiwick. He anticipates that unless there are, a substantial number of objections during the voir dire, he anticipates being able to accomplish that between 45 minutes to an hour with each of those three. With regard to Dr. Russell, we anticipate a half hour. Oh, I'm sorry, the only two from ARCCA, that's right.
You're only calling two? Which two? Are you calling the two that are certified as accident reconstructionists?
Doctors Richler and Wolf. Yes.
Mike goes out. Yannetti says something. Lally stands up and says something. Not sure what it is. I checked some other streams as well. But that's all we could hear from that hearing.
Oh, Local Jazz Hands, did you send a contribution through PayPal? Was that you? If it was, thank you so very much. I just got a notification. So that did go through, and I really very much appreciate it. Thank you. I'm assuming it's got to be you or somebody who's here in the stream. So thank you very much, whomever that was. Please show your face. Okay, so Peter Trago says that that's all that there was to it. I personally didn't find any vast misrepresentations there. Did you guys? But I don't know. We're going to see exactly. I mean, the judge is certainly going to have to specify exactly what it is through some kind of a motion and order or sanction during the hearing that's going to be happening on Tuesday. So to be continued. And we're going to have to see. Local Jazz Hands. Well, your secret's safe with me. I actually know the names of the real name of, well, I think all of my moderators and tons of members and viewers, and I would never disclose any information. So thank you very much. I really appreciate it. Seriously, thank you. Let's see. The two that testified at trial, what kind of, okay, gotcha. That was a rhetorical question. Cuff Off says, Jay May, she really does hate her job. She sounds perpetually disgusted with the whole thing and hates everyone. Yeah, I do kind of tend to agree with that. Now, I want to go back again and listen to again what that juror had to say about the ARCCA witnesses, now that we all have the perspective of exactly what is going on. And the ironic question is here, like, wow, kind of like, whatever it is the defense is going to go through, if someone's going to be sanctioned, really, what was it for? Maybe we'll listen to a little more of this juror interview. Do you guys want to? Are you down with that? You let me know what you want. I can be on for another, 20 or 25 minutes or so. Hey, Trailer Trash Barbie, I'm sorry to hear about your grandma. I got that message. I'm really sorry. Let me know what it is you guys want, okay?
Or is that not something you're trained to do?
That's not my forte. I'm not necessarily, all I know is based on what is provided to me in terms of evidence, but I'm not in any way, shape, or form a educated person on apology.
Well, luckily, there were two experts provided by the federal government from a company called ARCCA that testified, two doctors, and they were the last two witnesses to go. And in order to, they both testified that, according to the physics, the science and the physics, the injuries to John O'Keefe are not consistent with being hit by a car, and the damage to the vehicle is not consistent with hitting a pedestrian. And so those guys are, doctors, PhDs, they do this for a living, etc. And in order to find Karen Read guilty of manslaughter, you have to listen to the ARCCA experts and say, I don't believe them. So how did 8 jurors reach the conclusion that those guys didn't know what they were talking about?
It was as a direct result of Karen was there at that time, and John was there at the time, and it was believed that John died there. Therefore, right, at that location, and therefore it seemed like, and everybody, all the witnesses were suggesting that he was never inside the house, and as a direct result, the assumption, or if you connected the dots based on the evidence that was provided to us, it seemed like there was some sort of collision with the car, and therefore there was damages to the vehicle. And with the damages to the vehicle, and that both individuals were there and present, that the cause must have been, or somehow, some sort of involvement by Miss Reed. So that was how they all arrived at.
But how did they reconcile? Was the ARCCA testimony brought up by the people that thought that she was not guilty? Did they? I'm sure somebody in that room must have said, but these experts are telling us that that's not possible. And what was the answer to that? Like, did people say that that these guys are bullshit artists, that they're fake doctors? Like, what was the reason not to believe them?
I think the major rebuttal was, we don't know. And that was the other thing. It was very ambiguous on why these individuals were testifying. And so there was a question in the group on their essential integrity, in terms of, were they there as a direct result of somebody else trying to steer us in a different direction and confuse the jury. So it wasn't sure if it was insurance. It wasn't sure if it was, whether the Reeds were doing it, somebody else was doing it, or yourself was doing it to bring this group to try to testify so that it would sway the jury in one direction or the other. And that, I think that was one of the things that wasn't, again, unfortunate, because I guess it cannot be said, or didn't want to be revealed to us on what were the circumstances of why those individuals were testifying, other than they were testifying for the defense.
The fact that people like this are on juries is the reason I don't commit crimes.
Because now, obviously now that the trial's over, that they're not even defense experts, they're FBI. They were available to both sides, and only the defense called them. But it seems like the conversation in the room went, and they said, some people were suggesting maybe they were the insurance company, of course, because of course an insurance company would benefit from not having an automobile collision. Obviously, they wouldn't have to pay anything out. Or me, how did people thought I paid the ARCCA guys? That's wild.
Like anybody, somebody was trying to, again, to try to sway the jury in one direction versus the other.
I'm not that powerful, I promise you. I can't afford those guys. But so that's basically the reason that they came up with. They said they heard all their testimony, and then they said, nah, those guys are just probably paid off by the insurance company. We're going to disregard everything that they said.
Yeah, and one of the other reasons is because there was the other testimony of the individual from the dog bite expert, and all of the other things that the defense was trying to bring up, that again, wasn't sure if it was just to try to confuse or sway the jury in one direction versus the other, or create a jury which was created reasonable doubt, and therefore the vote had to be in one direction versus the other.
So it sounds like what you're saying is that some of the jurors in the room were saying that all of this defense third-party culprit thing, a dog biting John, this is all bullshit. This is all a smokescreen, and all these people, this dog bite expert they're bringing in, this is all a distraction from the fact that Karen Reed ran John over. Is that an accurate portrayal of what people were saying in that room?
That is correct.
Wow. Okay. So in order to believe that Karen Reed killed John O'Keefe, you have to believe that, and that John O'Keefe didn't go inside the house. You have to believe all.
And by the way, for anybody who just recently came in, this is Turtle Boy interviewing a juror from Carol Reed's Trial 1 jury. His name is Ronnie.
of the McAlberts who testified. And so am I correct in saying that they found the McAlberts to be convincing witnesses and truth tellers?
Correct. And I will say that that's to some respect, not only to say it's correct, but also to some respect, because there were some individuals who just looked at the facts. Again, the clear fact that Karen was operating a vehicle and drove the vehicle to that location, 34 Fairview. And then ultimately John O'Keefe lay at rest and died on essentially that address. And so everybody else is saying that he never entered the premises, therefore she must be at fault because he clearly did not just injure himself there. So
did anybody suggest that maybe the McAlberts are not being truthful, that maybe he did go inside? I assume somebody in the room, the not guilty voters, must have said that these people are lying, obviously. And what did people say to that? I mean, did some people believe at least that they weren't being honest?
Now, his answer here shocks me because essentially he says, because he's going to say, oh, no, those people, were just basing it on fact. He doesn't really admit that any of the jurors thought that the McCabe's and the Alberts were full of shit, which to me, that was so blatantly clear. And it seems like to a lot of you too. And I'm thinking definitely cuff you and J-May here.
I think the individuals who believe that she was not guilty was because of the mere fact that it was not adding up. So the injuries to John O'Keefe ultimately did not add up to the damage to the vehicle. And what ultimately injured him was, or led to his death, was a injury to his head, which was not very clear that type of damage could have occurred on the vehicle. And there was no damages on the vehicle that would indicate that kind of situation. So for those who were skeptical.
Well, I mean, doesn't that say it all? What he just explained about the juries that thought that she wasn't guilty, that, his injuries were inconsistent with a vehicle accident and that there was no damage to the car that indicated that the car had hit someone. Doesn't that say it all? Why the hell was it not a not guilty verdict? I do not understand.
That's what they were looking at.
Yeah, the Commonwealth alleges that that his arm, I still can't believe they said this theory, that the arm was out and that the arm is what caused the taillight basically acted as a knife and just sliced his arm up and then caused him to spin and then land 30 feet on the grass. And the gash in the back of the head came from hitting the grass, which they said was so hard that it somehow caused a gash in the back of his head. People really believe that?
Yeah, I mean, I don't think a lot of people in the room, some people who were experts in science, right, and physics, or have some knowledge of physics, necessarily believe that as the case, given the circumstances, that it was not very clear. But again, some individuals just believed at the circumstance that Karen and John were there at the same time, and John ultimately was killed.
And the tech stream data is what you mentioned to me a lot last time, and you said that was what the guilty people really stuck to, was the tech stream data. What was so convincing about the tech stream data for them?
It was a combination of the speed, and suddenly there's an increase in speed and a decrease in speed, consistent with maybe somebody backing up. And so that, looking at that, was kind of convincing that she must have accelerated in a backwards motion. And then
even though that 24 miles an hour in reverse 62 feet thing, there was no time associated with that. It was measured in what's called key cycles, and they couldn't explain, like, at least they didn't say for sure, like, this happened at 12:32. For all we know, that event could have happened at another time or another place, because they didn't give us a time. But people were pretty convinced just based on that alone that, yeah, that's proof positive that it happened at that exact same time.
I think it was a combination of, again, the circumstance that both individuals were there. There's evidence of a broken tail light, the injury to John, and the injuries that John sustained, and then ultimately that texting data was just another piece that indicated, yes, there must have been some movement. It was very interesting, though it wasn't very clear, and I think I said this last time, that it would have been nice to have somebody who is an expert in that, or somebody who has knowledge of that type of data from that company, right? From Lexus or whatever company, right? And to provide some information on if that can be accurate and what causes it to actually occur. So, for example, like I was saying, or I was thinking, like right now, as I'm driving home, right? My car could have slipped, and that could have triggered something, right, to suggest that maybe that will make a trigger that I'm driving kind of erratically, but it's not because of me, it's because of the ice and the snow on the roadway causing that to occur, which we all know that during this time frame, that's the type of weather that was being experienced by Karen during, and all individuals, I should say, during this time frame.
So if the defense had an expert from Toyota or whatever that could explain, like, is there anything that could make it look like you went a certain velocity and you really didn't? Maybe your tires were spinning, maybe the RPMs were up. That would have been a good witness for them to call.
I think that would have been helpful. That was definitely would be a helpful piece.
Okay. Let's talk about reasonable doubt. Going back and listening to it all, you know, the defense gave you this story about what they think happened, how John O'Keefe went in the house, he was beaten up, and he was left outside to die on the lawn, and then Karen Reed was framed there after the fact. All right. And what I didn't hear much from the defense in their closing arguments was about what reasonable doubt was. Did you guys discuss what reasonable doubt was in the jury room? Was that made clear what that was? Because how, some of
what a great question, because it doesn't sound like it, does it?
The things that you're saying right now is reasonable doubt. Even the arguments that Karen Reed, from the people that believe Karen Reed is guilty, they're making arguments for reasonable doubt. Did you guys understand what reasonable doubt was?
I believe we did, and that's where we kind of essentially got stuck, is because I think that's why it ended up as a hung jury, is because we kept rehashing that.
Well, that better be why it was a hung jury, because that is the sole purpose of deliberation as a jury. It's to determine if there is or is not reasonable doubt. And they did not understand it. They did not.
Second charge, in that some of us felt there was enough reasonable doubt and some of us did not. And not that we're trying to coerce anybody or try to convince anybody to vote one way versus the other.
But did they understand what reasonable doubt was?
Thank you, Turtle Boy.
I think everybody had a clear picture of it. That being said, I don't know if everybody wanted to vote in a particular way based on the reasonable doubt.
Now you obviously were.
I'm sorry, Ronnie, no disrespect, but what a dumb answer.
Not sequestered, but you were like not supposed to go home and watch any of this, consume any of this. I don't know if other jurors were. I'm assuming if you weren't, and even if you were, you probably wouldn't tell me, at least not on the show. So assuming that everybody actually followed, that order, they didn't read up about this case, et cetera, while this was going on. Do you think that, is it even possible for a case? Like, how do you guys do that? Like, how do you go home every day and not turn the TV on and not have bias when it comes to this story during this trial?
So it was very interesting because we tried, or it was one of those things where you do what you're asked, and I think it was a honest and trustable jury in that we all followed the rules, which is not to watch TV, diet from that, diet from reading the news or any of the tickers, and not pay attention to those things. Or if something were to come up, we were required to report it as such, that we had some sort of interaction. But like I said, most of us, I should say all of us, were pretty good about it. And we just, dieted from the news and the media.
All right. So I'm sure a million people have questions. So I'm going to read some questions that we have from Turtle Riders in the chat here, because I'm sure there's a bunch. Okay. Our first one, this is a $10 one from Jay. And again, if you guys are going to write them in, keep them brief. I will not read your freaking paragraph questions. So keep it brief. So how do you overlook paramedics' omission of possible, this is from Jay for $10, possible vehicle strike in the report narrative? The radio report to the hospital and the other report are both available to be examined, and would have been two other opportunities for this medic.
You ignore that because the medic didn't tell anybody that until trial. Or she told the doctors, or he told the doctors there was a possible vehicle, it possibly had to do with, it was a vehicle accident, but left it at that, and nobody said that those words came out of Karen Reed's mouth. We know that.
Are two opportunities for this medic to have reported document if it actually happened.
So I think one of the things there is it would have been nice if that was all documented per se. Again, the jury is limited on what we are actually able to see in terms of the documentation. So we are only given a certain piece of the documentation, and majority of it is based on the testimony of the individual. So the individual can read the document, or they need to read the document and then kind of say it out loud to the jury, and that's what's provided to us.
Next question here. This is a random one. Lem sends for $50. Long time, first time. Could you please ask the juror if they ever followed Turtle Boy, Olivia Lambo, or Joe Flipperhead? Do you follow any of those accounts on Twitter? Did you follow Turtle Boy before any of this? You probably know who I was. That's okay.
Sorry, first time to learn about any of those, and in fact, first time I learned about Dr. Turtle Boy was when I got contacted. So,
well, thank you for respecting my pronouns. All right. So, do you have, now that the trial's over, have you consumed any of this, or you just went back to your life like whatever?
I think, as at least for me, and I believe the majority of the jury, we all wanted to just go back to our normal lives, and we haven't really followed much of it other than knowing full well, just occasionally, that it was a hung jury, and that it's probably going to be retried, and we know that it's being retried, and we know the date, but I honestly have not gone and searched anything or researched much of anything in terms of the case, because I lived it.
Do you think if the defense had been allowed to mention that there was a federal investigation into the investigation itself, and that the FBI paid for those ARCCA experts to be there, would that have affected the outcome of the trial?
Great question. And now look at all the controversy over that.
I believe that it would definitely have changed. Most likely would have changed the hung jury, or made it more unanimous of a vote, so it would be easier to kind of look at And they would still ask us to continue deliberation because it would just be a few individuals left.
Next one here. This is from $30 from Dawn. Could the juror confirm if the jury slip was the updated version requested by Alan Jackson, or is it the one that they never updated? Did you guys get confused by that?
Yeah, so we got two different slips. The first slip that we got was updated and changed. I cannot recall the exact date or day that we were given the new slip, but we definitely were given a new slip that was updated charges and updated verbiage.
Okay. This is from Kim for $10. Says, what questions were you asked of when you were chosen as a juror? Good question. During the voir dire, when you guys were called up, and your little conference there with the judge and the attorneys, what were they asking you? What questions?
Each individual is different. I think the major question was for me is that would I be biased in any way, shape, or form because of my medical training? And so that wouldn't overlook the evidence and have an opinion and have a bias as a direct result of my medical training without looking at the evidence entirely and kind of, do I have a bias versus or against or for law enforcement?
Really? Who asked you that question? The Commonwealth or the defense? Do you remember?
I believe it was more of the defense.
Okay. The defense asked you if you had a bias towards law enforcement? Okay.
I believe it was the defense who asked.
And you said you were just indifferent, whatever. Because if you said, yeah, my dad's a cop or something like that, you'd be the first one on the cutting line. If you said something like that.
I don't know. Perhaps I tried to be honest, I tried to get out of it. I actually thought I was just going in just the first day. I didn't even know what the whole thing was until at the end when they were starting to select us, what was going on. But I thought it was just going to be a regular jury.
Were you there April 16th, the first day of juror selection?
No, I was there on the second day, on the 17th.
Okay, the second day. They picked 7 that day. So that's interesting. And so you went into that and you must have seen crowds of people outside. Were you like, what the hell is this? What's going on here?
Yeah, I actually didn't realize what we were being selected for and what was the case until it was read to us by the judge. But essentially, I thought I was going to go in my typical jury duty, go in there and spend like maybe a few hours and then get out, be able to have lunch and have the rest of my afternoon, as opposed to the other way around where I was there for a little while for a full jury selection.
Next one is for Mackenzie. She sends $5, and she kind of asks my question about the reconstruction experts, FBI, etc. And then she says at the end, like, how she says, because I don't understand how someone could take Officer Paul's reconstruction seriously and disregard the 2 defense experts, because he was
amen to that, questioner,
the only one that was the expert that explained for the Commonwealth how John O'Keefe got hit by a car. Did jurors actually take him seriously? Did they think his testimony went well?
Again, I don't think necessarily we were looking at one individual for their testimony. We kind of looked at the whole picture, bringing it back to the circumstance that somebody is dead, and those 2 individuals that came to that household or that address, one of those individuals is dead and the other individual is alive. Ultimately, and there's damage to the vehicle, then that individual must be responsible.
Dude, fucking brilliant. The logic is one of the individuals that went to the house is dead. One is alive due to the fact that there is some kind of damage, even though it's inconsistent with the injuries on the dead person's body. there's some kind of damage on the vehicle. One person's dead, one person's alive. Therefore, the person who is alive must have committed the crime. I freaking love it.
For that injury.
So, like, you know, her dropping him off there, and whatever, like, that's not proof of anything, right? I mean, that's bad. That's, God forbid, like, I hope nobody else ends up in a situation where they drop someone up the house and then they end up dead, and it's like, well, you dropped them off, so you obviously killed them.
Exactly.
But you mentioned the taillight. That's the only real physical piece of evidence that they had against Karen Reed. However, was it brought up during deliberations that the Canton police searched the scene at 7 a.m. with a leaf blower, and they videotaped it, and they didn't find a single piece of bright red taillight on the snow, yet they found 45 pieces over the next few weeks? Was there any discussion that perhaps taillight might have been planted?
Good call.
There were some individuals that were definitely stuck on that and believed that was reasonable doubt, but there was some individuals that believed that it made a bit, again, just circumstance or happenstance, that maybe there wasn't enough snow at the time, and therefore now ultimately now the ground is covered, and therefore you couldn't see the pieces because it's covered, but prior to that, maybe now you can see it. So,
well, it would be the opposite. Because
Yeah.
when they first when the Canton police got there
Hello,
at
Turtle
7
Boy.
o'clock, there was 3 inches of snow on the ground, tops, maybe 4, 3 to 4. And it's a lot of taillight, right? And they had their leaf blower out, and they have a video of him finding these transparent pieces of cocktail glass. Paul Gallagher finds them. So they were able to find transparent pieces of cocktail glass, but not all that red taillight. Was the general consensus that the Canton police are just completely incompetent? Wouldn't they have to be if they didn't find any?
And don't forget that they took these samples of snow that had blood in them, and rather than, you know, putting them in proper evidence containers that would preserve the evidence properly, they put them in red Solo cups that you play beer pong with.
Taillight? Was that the consensus?
I don't think that was the consensus. I think the consensus was just, again, they looked at all of the overarching evidence, not just that one little piece. So individuals looked at everything and said, nope, that's not enough to say that that created reasonable doubt.
All right, next question here is from Melanie, sends $10, goes, did he see the footage of Alan Jackson in court arguing with the judge about how the confusing juror forms were, and what did he think of that? Did you guys know that battle was going on inside the courtroom?
I do not know of that in particular. I never saw the footage, but I understand that it was very confusing. And again, unfortunately, it's a fallacy in the system that it wasn't clarified for us that we could look at each individual charge independently of each other.
Okay. Natalie sends $5 and says, what arguments or comments from guilty jurors led you to temporarily change from not guilty?
So to not guilty,
From not guilty to guilty.
Not guilty to guilty. I think ultimately, again, some of us broke down because it was very clear. They clearly displayed that both individuals were under the influence of alcohol at the time, and therefore should not have been operating a vehicle. So the operation of the vehicle, and that is that second charge, which is involuntary manslaughter as a direct result of operating a vehicle under the influence of alcohol. So that is what a lot of
that's called DUI or DWI. It's not called vehicular, it's not called manslaughter. Murder in the second degree.
People kind of swayed on that, yes, they shouldn't have been operating the vehicle, and it's not murder too, but could it be that she operated the vehicle negligently and therefore led to involuntary manslaughter? So that's where there could be a sway.
So it was the fact that she was, admittedly had, so I would say, so the testimony from the police about she had 4 drinks here, that was very effective, obviously, because ultimately they said, well, she was drinking and driving, so she probably did it.
I think it was not only that, but the video footage of the drinks that she was having was very strong.
Oh my God.
In leading to that kind of opinion and thought process.
Okay. Even though the rest of them were also drunk. I mean, everyone was drinking and driving that night, including the police, and that didn't bother anyone else.
I think it bothered everybody, but ultimately we have to look at who's being charged here, and the individual who's being charged was Karen. So unfortunately, nobody else was being charged with it. It was just Karen. So therefore, Karen must have been, and both people were there during that same time frame. So
that's interesting that you say that, because, and I've long argued this, that being in the defendant's chair is you're already losing. You're already down 20-0, something like that, because you're here, you've been charged, you probably did it, or else you wouldn't be here right now. So you would argue that, like, the fact that she was charged at all and sitting in that defendant's chair and no one else was charged is pretty, that people were suggesting that was, pretty solid reason to vote guilty.
I believe that it was a combination of, so theoretically anybody, right, should be considered innocent until proven guilty. But here they displayed clearly, the Commonwealth displayed that she was under the influence of alcohol, even though there was no breathalyzer per se at that exact time frame when the incident occurred, right? It was after the fact. But based on the evidence of the receipts and the video showing that she was under the influence of alcohol and then operating the vehicle, that would be easy to kind of charge her with involuntary manslaughter, operating a vehicle under the influence.
So I have a question here from another juror. Is actually from the one of the jurors who was not chosen to deliberate, and I'm getting a message from them now, and they said this is the quote: "Did the jury ever discuss to a moral certainty as part of the reasonable doubt discussion, or would having an attorney in the room have been helpful for that?" Because I believe one of the jurors who was randomly chosen not to be in the jury was an attorney. So would it have helped to have an attorney in the room describe what to a moral certainty was? Was that discussed at all?
I think having that level of expertise in the room would have been helpful for everything, including the fact that, number one, that all 3 charges could be looked at independently, and somebody who has that level of expertise to clearly indicate to us the moral certitude of reasonable doubt.
Okay. Because they went on to say that when we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs. So obviously this discussion didn't even take place at all. What a moral
So
certainty.
I won't say that it didn't take place, because we read that statement multiple times to the group. I don't know if it hit home to the group more so if that individual was there to provide that level of expertise. Okay. So if somebody was there to provide that level of expertise, I think it would have been more realistic or tangible to the jury or the group rather than not. Because although it was read multiple times, and I will say that we read it multiple times, and I was one of the individuals who was reading it multiple times. It clearly may not have made an impact or have been as impactful as if there was somebody with that kind of experience and that level of knowledge.
Yeah, coincidentally, she happened to be one of the 2 names chosen out of that box on the last day. And there was when I was watching the testimony of these people, there was 3 jurors in particular, all women, who were making visual representations with their facial reactions that they believed that that Michael Proctor was an asshole and that the Commonwealth was full of shit and that Karen Reed was clearly innocent. And coincidentally, all 3 of those people making faces were all chosen on the last day not to participate in deliberations. Did you guys did you guys ever talk about this before you started to deliberate? And what was it like the moment that you went in that room? Like, what's the first thing people said? Like, okay, so let's get this over with, or what do you guys want to do first? What was that like?
We actually didn't. So in terms of just going into the room before deliberation, we really didn't talk much about the case when we were, other than a couple, comments here and there. And even when we were, when we were together, we were not really deliberating or talking a lot about the case. But we did definitely talk about the case during the deliberation process.
That's how it's supposed
And
to be.
we tried to figure out where to start. I think ultimately we came up with looking at all the evidence and looking at the video files, looking at the pieces of evidence that was provided to us. And we kind of looked at all of those over the course of the time frame that we did our deliberations.
This is from Kelly. If Chloe bit, you must have quit for $10. Says, I want to thank you, Ronnie, for coming on to stand up for what is right in the name of justice. What was the biggest thing that caused you to believe in her innocence or that there was reasonable doubt?
Ultimately, what made me sway back to reasonable doubt was, yes, she was there and he was there at the same time frame. However, the injury that ultimately causes death was inconsistent with the physics of the damage to the car. And the other piece that causes death was the hypothermia. So those 2 pieces, which was presented to us, was the basal skull fracture to the back of his head and the hypothermia was inconsistent with the damages to the vehicle. And so
ARCCA,
ultimately, what I also
ARCCA.
thought about was that he was the one who kind of, and I'm not trying to put blame on him, but he ultimately was the one who was insistent to try to go back and go to this place. So 34 Fairview, he was the one who kind of programmed the GPS to that location. And she was the one who was asking to just go and have something to eat. Granted, it was a piece.
Okay, guys. All right, guys. I'm going to wrap it up here. We're at like 2 hours now, but thank you guys for being here with me and for having interest in this case. Please, please, please hit like. Please share the Karen Reed videos because I do want people to watch so I can cover this case with you guys as it goes on, the trial number 2. And I definitely need your help because YouTube is opposing me a bit. So I really appreciate all of you guys. Again, thank you so much for being here. There will be more content coming up this week. And thank you guys. I had this past week off, and after I got over the flu, we did a lot of live streams. Thank you guys for being here. I've really enjoyed interacting with you guys and talking about the major issues in this case and issues of justice. You guys are awesome. Thank you, moderators, subs, members. Welcome, new members. We will be doing some member only things this week. And yeah, justice for Officer John O'Keefe and Karen Reed. And everyone, have a great night.